All right, hi everyone. This is Ravneet, and today I will be presenting my major paper on foreign direct investment law. And my tagline is neutral on paper but racial in practice. All right, so before we get into, the presentation, I want everyone to close their eyes and we'll do sort of a hypothetical scenario. So I want you all to close your eyes and imagine something. Imagine that a Canadian, foreign company enters into your community. It starts extracting vital minerals and resources from your land. And then when you and your people are trying to protest and trying to defend your land, your water, your resources, the law does not see your actions as protection, but it sees them as a risk to this foreign Canadian investor. And now imagine that on top of that, tribunals side with the other side. So they go with that Canadian foreign entity and they turn around and you get fined for billions and billions of dollars. This is the current world of foreign direct investment law. So everyone, today I will be showing you how Canadian FDI law presents itself as, neutral and apolitical, but in practice it reproduces racialized patterns of harm across the global South. Okay. All right. So to understand how we get from legal neutrality to racialized outcomes, here's the roadmap or agenda for today. So I'll begin by, exploring and explaining what FDI is and then what FDI law are. And then I'll introduce my thesis statement, grounded in critical race theory. We'll go into three case studies for three different countries in the global South, specifically Peru, Eritrea, and Pakistan. And each of these case studies will sort of show a different way that Canadian FDI law has impacted racialized communities. And from there, I'll connect all these cases through legal analysis, offer some recommendations, and then finish with some questions. So before we get into the legal sort of explanation, I want to sort of introduce what FDI is. So what exactly is FDI and why does it matter to Canada? So foreign direct investment is when a company from one country, typically a country in the global north, invests in another country in order to obtain long-term or significant control over, a typical like a specific sort of asset or resource. And typically the country that's being invested in my case examples, are those in the global south. And the sort of investments can include anything, ranging from mines to energy projects to other forms of resource extraction. And so, for background, Canada actually plays quite a big role in global FDI patterns. Canada's mining companies, for instance, operate in over 95 foreign entities. They actually control over $240 billion in extractive assets abroad. And most importantly, two-thirds of those assets are located in racialized regions in the global south, ranging, from South America to Africa to Asia. And so this sort of background just kind of shows a global footprint that makes Canada's FDI law so exploitative and so, broad and substantive and significant. So now let's look at it from a legal lens. So FDI law isn't just, about business and business numbers and return on investments. It's, it's governed by a legal infrastructure behind it as well. So FDI law is a system that governs how foreign entities and investors operate abroad. It includes it supposedly includes protections like fair and equitable treatment, protections against expropriation, access to investor state arbitrations, which I will definitely be getting into in my case study examples. But these laws, like as you can see, these laws typically protect investors' properties and bundles of rights, and they outline steps where it's made most easy for them to pursue, dispute resolutions. But one important clarification I have, and this comes directly from my paper as well, is that Canada doesn't actually have a single FDI statute regulation, legislation. Rather, it relies on a patchwork of different legal frameworks. So as you can see on the slide shown, for inbound investments, if we were talking about those, we would rely on the Investment Canada Act. For outbound investments abroad, which majority of my case examples are about, we're talking about treaties like FIPAs, as you can see there, Foreign Investment Protection and Promotion Acts, bilateral investment treaties and investment chapters and FTAs, which are free trade agreements. I'm also going to be talking about disputes and sort of arbitrations and how settlements work in the international arbitration system, primarily through the ICSID. And then also there are the soft bodies of laws as seen below. So this fragmented structure sort of shows how it can be difficult to hold global north actors accountable and how having so many sort of patchworks of legal systems helps them maintain this illusion of neutrality when in actuality nothing's neutral about it whatsoever. And so this kind of transitions and brings me to the central motivation behind my research proposal and research paper, and that's that FDI law is often, celebrated as a development tool, but there's this, dark and unexplored side, and this is where my research comes into. So, what exactly am I arguing? My thesis is that through an intersectional, critical race theory lens, Canadian foreign direct investment laws, while appearing neutral, actually reinforce racialized power structures that deepen extraction, limit global South self-determination, and normalize structural inequality. In other languages, the outcomes of FDI law are not neutral. And then if we go into my research problem to analyze this, I lead my research with a key question, which is, are Canadian FDI laws racially discriminatory? And to look at these, these, I look at how these laws enable colonial style extraction. So I try to make a really big connection and analogy that, the colonialism, that we associate with the 18th, 19th, and early 20th century hasn't really gone away. It's under a different guise in modern day capitalism, and now it's been reworked under FDI. And so, sort of, foreign direct investment laws are just another way of colonial extraction. I also want to look at how these laws silence indigenous and racialized voices, prioritize investment rights over human rights, and punish global South sovereignty under the guise of development. And this is sort of where that critical race theory lens and analysis becomes essential. It kind of reveals that it doesn't kind of reveal, it does reveal that there's racial structures beneath all this legal lingo. So, FDI law is a neutral appearance. So let's look more closely at how neutrality is sort of constructed within this patchwork of Canadian FDI laws. So on paper, FDI law presents itself as quite objective and colorblind. For instance, the treaties that I was alluding to earlier, they use universal language, emphasizing equality, stability, and fairness. There's terms and clauses like the FETs everywhere, which is the fair and equitable treatment, which sounds quite neutral, but in application is not neutral whatsoever. And we will see it across, I think, two of the three cases that I'm about to bring up. And international arbitration forums like the ICSID claim to be apolitical and, the outside the influence of, politics, but at the end of the day, they just appease to the global north, you know, board of, companies and, white board of directors while silencing the voices of those people of color who are marginalized and already ostracized from society and already like unknowing of how business works in the grand scheme of things. So FDI law sort of frames itself, as you can see, as like purely commercial law, but um, its consequences are very, racialized, political, and, very much exploitative of those who are already marginalized in society. So there's a couple of key themes that I want to touch on, but I won't touch on too deeply on this because I want this more so to be within my paper, but I want to tell you guys anyways. Um, so when we put critical race theory, post-colonial theory, and racial capitalism next to, my thesis statement, this whole new picture emerges. These theories sort of show that FDI laws, really do reproduce this dependency theory. And I'm sure a lot of you guys know this dependency theory of where, global South nations are forced and sort of made to depend on global North nations. And even if that was not the case ever, it becomes sort of necessary in order to, gain capital within like this global economy and to, be part of trade agreements, et cetera, et cetera. These theories also show that modern investment agreements echo historical colonial relations, like I was alluding to earlier, like colonialism really hasn't disappeared. It's just under a different guise called FDI law. And global markets are structured by racial hierarchy rooted in racial capitalism and Black Marxism. So these ideals of, slavery, or these notions of slavery and this ideal that, oh, slavery has ended isn't actually true. It's just under, a different guise of forced labor, and it's now being slowly, um, slowly sort of, hidden under FDI laws. So using these lenses, we can reinterpret FDI not as neutral or as like a purely economic tool, but as a continuation of earlier extractive like practices. So let's get into the case studies. So the first case study is by Bear Creek. Basically, in the global south region of Puno, Peru, Bear Creek, which is a Vancouver-based mining company, they sought to develop a silver mine on Amera's indigenous lands. And obviously, local communities protested due to the threat to water, agriculture, and their economy. And this is not Bear Creek's first rodeo, nor a Canadian mining company's first rodeo. And on Indigenous land, there's a map right to the left on the screen, which shows how many Indigenous communities have been affected across South America and Latin America. And basically, the Indigenous and local communities' concerns escalated eventually into protest, to which Peru actually responded by revoking Bear Creek's authorization. Um, and then this is now where sort of FDI law enters. Bear Creek then turned around and filed a claim under the Canadian-Peru Free Trade Agreement, arguing that Peru had indirectly expropriated its investments and violated the clause of fair and equitable treatment, which of course they would say that. And unfortunately, the tribunal agreed with this large, imposing Canadian corporation. And then they ordered Peru to pay Bear Creek about $18 million USD in damages. So crucially, this basically showed that it rejected Peru's argument that the revocation was necessary to protect Indigenous communities. And in the eyes of FDI law, Indigenous protests became social conflict, not a legitimate act of self-defense. That's not the only case. So now we go, across the ocean to Eritrea. And basically in Eritrea's Bisha mine, Canadian company Nevsun benefited from conscripted labor, where workers were effectively forced into forced labor through the state's military service system. So this was sort of like a joint venture between a Canadian mining corp and the Eritrean military itself. And basically, throughout this entire process, Eritrean, workers were treated so poorly. And then in the end, three Eritrean refugees later sued Nevsun, alleging, slavery, discrimination, torture, etc. Unfortunately, Nevsun, obviously being the big bad corporation, tried to dismiss the case, arguing that Canadian courts shouldn't judge the acts of a foreign sovereign and that international norms like prohibitions on slavery couldn't be applied to corporations. And in 2020, the Supreme Court of Canada fortunately disagreed, allowing the case to proceed. And although the Supreme Court allowed the case to proceed, the underlying FDI structures that enabled Nevsun in the first place to exploit these workers and force them into coerced labor still remains untouched today. So FDI law still offers no meaningful accountability whatsoever for the workers that were harmed, nor does it offer any accountability to that company that harmed these workers in the first place. So this sort of shows how FDI law really silences marginalized voices, even when you bring these voices, to costly litigation, when you bring them into the costly litigation system. And then our last case is one in Pakistan, and it sort of highlights how FDI laws interact with state sovereignty in, a quite marginalized area, basically in Pakistan's Balochistan region, which is an extremely, ostracized and highly militarized area. TCC, a company which is a joint venture with a Canadian Barrick gold mining company, they sought control over the world's largest copper gold deposits. However, concerns arose from Baloch locals, including concerns about environmental risks, resource sovereignty, decision-making power, etc., all reasonable concerns. And then when Pakistan's Supreme Court invalidated TCC's agreements on constitutional grounds, so aligning with the Baloch locals, TCC actually turned around and brought this to international arbitration under FDI law. So they brought it to the ICSID. And the consequences were enormous. ICSID ordered Pakistan to pay nearly $6 billion, one of the largest awards ever, to TCC. And the threat of such a significant award destabilized public finances in that area so much so that it forced Pakistan back to the negotiation table in 2022. So basically, despite Pakistan and Balochistan not wanting TCC to have, to be running this operation, this copper gold deposit operation, they had no choice but to be like, okay, bring it back. Because we're so, we basically just have this huge deficit in our pockets and don't know what else to do. And throughout all of this, you'll notice that there was no, Baloch community members that participated, no voice or understanding of this marginalized community. And it sort of goes to show that FDI law, you know, can punish global South courts and nations for just trying to do their jobs, to try to advocate for those who really need help. And at the end of the day, FDI laws will turn around and just benefit those who are from the global North. So what connects these three cases? In each of the cases, the investor rights from the global north were enforceable and immediate, right? The community rights were weakened, delayed, or, you know, succumbed to nothing. And then racialized harm were legally irrelevant, basically. In Peru, you'll see indigenous resistance became investors' risk, and Eritrea forced labor was invisible. And then in Pakistan, state sovereignty was punished. So you can see how neutrality really collapses under the weights of these outcomes, and it really shows that there needs to be a CRT analysis done to FDI law and that it's not neutral. So across all three case findings, we observe that there's, resistance from global South communities, but it's reframed as risk. We also see how there's investor rights, whether fair, equitable treatment, or expropriation, which are prioritized rather than those voices that are being marginalized. We see that sovereignty is punished through billion-dollar awards. We see that benefits flow to Canadian corporations, rather than benefits being given to those whose water is being damaged, land is being taken away, people are into forced labor. And so you can see these are really not isolated, issues. We saw a case in Asia, a case in Africa, and a case in South America, right? So, just in general, from a recommendation space, how would an FDI, just patchwork of legal frameworks sort of look like? So, my recommendations to address this racial imbalance include renegotiating treaties so that human rights and indigenous rights have primacy over investor claims, narrowing FET and expropriation protections so that states can act in defense of these marginalized and ostracized communities, adding explicit racial justice clauses to every FDI treaty, because if we can add FET clauses, then we can add racially conscious clauses, and then reconsidering or eliminating, this sort of ISDS, or then flipping the burden of proof so that companies must show that they cause no racialized harm. So to conclude, Canadian FDI law may appear, neutral and apolitical, but when examined through CRT and real case studies, it becomes clear that the system reproduces racialized patterns of extraction, invisibility, and harm. And so using CRT reveals this deeper structure that FDI law continues colonial extraction, disciplines global South governance beyond any power that they should have, and elevates investors' expectations and basically global, North's expectations over human dignity and over, human rights of those living in the global South. So to move towards justice, we definitely need an investment and FDI system that centers people and not capital, and that refuses to treat racialized communities as disposable. And so this brings me to my questions to reflect on. I wanted to ask, whose perspectives did you find wanting to hear more about? Or whose stories did you feel were sort of untold? I think there's a lot of nuance to these stories, and there's a lot that can emerge if I talk about laborers or women in these contexts. So let me know if that's something you think you echo as well. If you map the power relations in each case, so if we go from Canada to the corporation to the state to the global South community, where do you see unexpected dynamics, contradictions, or slippages? And in these examples, investors can exit, but GS states, global South states cannot exit their land or conditions. So how can I more sort of sharply show this asymmetry? If you guys have any ideas, I would really appreciate it. Thank you so much for listening to my presentation. If you have any questions, please let me know. And I look forward to your feedback. Thank you.